All right, so we're on the record in docket 23-03791. That is People of the State of Michigan versus Elijah Shakur. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
Thank you. Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Shakur. Mr. Shakur is present and standing to my right.
And sir, you are Elijah Shakur, that's correct? Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe this is going to be a plea to domestic violence second offense with a killabrew to 180 days, which is what the court was going to impose previously before the plea was withdrawn. And I believe the court should have the PAC code for it, but if you need it again, let me know.
So it is a plea to count one with one prior offense, is that correct?
Yes, so it would be a DV with the second offense.
The ultimate penalty is 1 year. I'm not sure what the cash amount is.
Let me scroll down here. 1 year and or $1,000.
$1,000, and then I have the PAC code because I've got it's 78. No. It is 750.841B.
No. So the PAC code would be
For the DV second, right?
for DV would be 750.812.
Okay.
And then there's a second PAC code for the second offense notice.
And that would be?
And that is 750.813.
813. Okay. All right. So Ms. Schroeder, you heard the terms of negotiation is plea to count one with a 1 second second offense prior, and then the third offense notice and the habitual fourth would be dismissed. Is that correct, Ms. Wilson?
That is correct, Your Honor.
And that is correct, Your Honor, and I will make some record as to the goings on here shortly if the court will allow.
Third offense notice and habitual would be dismissed. And then there's a killabrew to 180 days. Is that what you indicated?
That is correct, Your Honor.
Yes.
All right, Ms. Schroeder, would you like to take this time to make a record, or after your client gives their advice of rights on the DV2? It's up to you.
I'll do it now. I think it makes sense to do it now. Your Honor, as the court I'm sure does recall, we were here back in March, I believe, originally for a sentencing in this matter. At that time, the court indicated it was going to not follow the original killabrew agreement, which is going to be to no upfront jail time of sentencing. At that time, Mr. Shakur withdrew his original guilty plea to this same charge or final disposition. And he was remanded at that point to the Ingham County Jail pending today's date. And the days after that court hearing, I had communications back and forth with Mr. Shakur using the jail. They have an inmate system that we can go back and forth, the attorneys can. And he indicated he'd been doing a lot of thinking since what had happened and listening to what the court had said at that hearing in March and reflection. And there was a communication of a desire to, if possible, get the original plea offer back on the table, and with the full knowledge that he would be almost assuredly be looking at jail time still regardless. He, myself, and my immediate supervisor, Deputy Chief Stephen Cornish, met via Polycom about, I think it was 2 or 3 weeks ago, and spent about half an hour going over what had happened previously, what had happened in court, and verifying both myself and Mr. Cornish that this was what Mr. Shakur wished to do upon I believe a great deal of self-reflection and understanding and explaining to us what had gone wrong, I guess, for lack of a better way to put it, and his thinking on that day and the days leading up to the original sentencing date. At that time, I reached out to the prosecutor and she indicated that we could still do that plea offer, and that brings us here today.
All right, thank you. And so that's all a fair statement, Mr. Shakur. concerning statements been made, and it's your understanding that you're going to be pleading guilty today to the DV second. It's the ultimate penalty is 1 year under $1,000. There's a killabrew agreement between the lawyers that you serve no greater than 180 days in the county jail, and the count three offense notice and the habitual would be dismissed. Is that your understanding to what everybody's talked about here today? All right. So we'll go through your advice of rights one more time in regards to the plea. You understand you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Aaron Schroeder. She would be present to cross-examine any witnesses or cross-examine any witness or contest any charges brought against you at trial by the people of the state of Michigan. Do you understand that?
Yes, sir.
You have the right to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If you're please accepted, you'll give up the claim. The plea was a result of any promises other than what's been stated on the record this time, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal issues that would come from a trial. You won't be having a trial today. You'll be pleading guilty instead. Is it your wish today to plead guilty to the count one of the count one of domestic violence with the second offense notice, a 1 year and or $1,000?
Yes.
All right, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
I'm going to bring your attention back to December 25th of 2023 at the offense location of 139 South Hayford, City of Lansing, Ingham County. Were you at 139 South Hayford in the City of Lansing on December 25th, 2023? And who is Heather Shakur to you? All right. And at that time, did you have contact with Heather Shakur, your wife? Did you offensively touch her in some way that was not done in self-defense?
Yes, sir.
And what did you do?
Sure.
And that was not done in self-defense, and you meant to hit her?
Yes, sir.
All right. And then you also indicate that you've previously been convicted of violating 750.812, that you were convicted of assault, previous domestic violence assault on April 1st, 2015. Is that correct, sir?
First 2015.
Was the conviction date for your prior offense? I've got two to work
I
from.
think it was 2013, sir, and I got convicted and I got out of prison in 2013.
Right. So I've got a previous conviction
Yes, sir.
on 2000 and April 1st. I haven't on mine. It says both were on April 1st, 2015.
I went to prison in 2013, sir,
Okay.
and I got out of prison in the end of 2015, sir.
All right. But you
Yes,
do.
sir. Yes, sir.
Okay. You acknowledge the prior conviction.
Yeah, yes.
All right. All right. Anything towards a factual basis in regards to the domestic assault or the prior conviction, Ms. Wilson? Ms. Schroeder.
Not for the defense.
Okay, I find that there is a DV second for the prior conviction be knowing, voluntarily, and accurately made. We have a pre-sentence done on this. I don't know if you wanted to. So how did you want to proceed to sentencing? We have a pre-sentence done. This looks like the original agreement, except for the time difference. Ms. Wilson, how did you want to proceed?
Thank you, Your Honor. Ms. Schroeder and I have talked previously, and the people have no objection to immediate sentencing. As the court has indicated, we already have a PSI done. So I think immediate sentencing is appropriate.
All right, Ms. Schroeder, is that a fair statement?
I would agree with that, Your Honor.
All right, and you've had the opportunity. I know that previously you've gone through the pre-sentence report with your client at the initial initial sentencing. Any deletions, corrections to that report? You had some the first time, and in regards to contesting some of it. Do you just stand on your prior corrections, or do you have anything you would like to add? You've already added some for the record to some of the reflection and the ability to meet with your chief assistant in regards to the actual plea, this actual plea taking place. Anything else you want to add, Ms. Concerning the pre-sentence report, and then we'll go to allocution.
Nothing further. Well, I think based on some of the subsequent conversations I've had with Mr. Shakur, I think a lot of the statements even that he made on that day, by his own admission, were self-serving. And that is part of his self-reflection. So I think his statements are probably something he's going to need to kind of put on the record here as to corrections regarding that.
All right. Mr. Shakur, Mr.
Yep, Your Honor, before we move into that, I just want to make sure, I see on my version of the PSI that there was a victim impact statement attached, but I didn't have it. I just want to make sure it's in the court file.
That is a good question. I have a victim impact statement
Perfect, okay.
concerning, and it's a copy from the prosecutor. Is that the
Yes,
same
correct.
one?
I just want to make sure that the court had it.
All right, I do have that. Thank you. Mr. Shakur, is there anything you'd like to say to the court before the court passes sentence? You know there's an agreement of no greater than 180 days on this file. Is there anything you'd like to say to the court?
I think if you want to read what you've written down, are you able to? I think he has something he would like
All right.
to read.
Your Honor, I'm truly sorry for the actions I've recently taken. I take full responsibility and am fully accountable for everything that's taken place and everything that I have done. I would like to apologize to my wife, my brother, my sister, my mother, my children. And if or when I could get out, I would like to reunite with my family and get the help I need to get my health in check. Would greatly appreciate it. And as a husband and father, I take full responsibility for my lack of control over my aggressions. And I am willing to do whatever it takes to learn to be a better person. And I apologize to the courts, the probation officers, and my lawyer, especially for not taking responsibility for my actions. Thank you.
Thank you. Is there any restitution in the matter that you're aware of, Ms. Wilson?
No, Your Honor, thank you.
Mr. Shakur, this has been a long path that we've gone through. It's been a little windy, but ultimately, your criminal history indicates that you're probably not a person for probation at this point. But I applaud your willingness to start anew when it's time and to reach out and to seek whatever help you need for whatever reason. And I don't know the answer to that, okay? But for whatever reason, you're put in a situation where you have an anger management issue, and then you tend to hit your loved ones and the people who care about you most. For whatever reason, I don't know. That's what domestic violence is to me. Domestic violence is to me is we tend to hit our loved ones for some reason. And maybe they're the ones, they install the button so they know where to push them. I don't know. I don't have the answers to that. But I do know the onus is on us. The onus is on us in our response. So it is the sentence of this court based on today's plea and the revitalization. I'm going to stay with the Killebrew agreement of 180 days in jail. Credit, I think, for 39 at this point in time. 3 days plus the 30. I think it's.
I have not done the math. Your Honor.
Okay.
I think he was remanded on the 21st. He had 3 days credit at that time.
Right.
So I think that's 32 days.
32 days. Okay.
I could be wrong.
You said 21st?
Yes.
So we'll do credit for 32 days. The fines and costs I'm going to indicate are $250 fine, $250 cost, crime victims' rights fee of $75, state fee of $50 for $625. I'm not ordering any probation. And I will do another judgment of sentence to that. So it's 180 days for 32 days credit served, no probation. $625 will be to the city of Lansing. Once you're able to get out and get everything going, okay, you can, that's probably enough to refer to collections, right? So we'll refer that to collections. So once you're out and check with the city of Lansing, that'll keep you out of the bench warrant cycle, okay? Because if you don't pay, then they're gonna get a show cause, you'll come in, you want to just avoid all that, all right? All right.
I'll pay it, though. I usually pay all mine.
All right,
That's
so $625 to the city of Lansing, and that'll be referred to collections. Anything else for the record in 23-03791, Ms. Wilson?
Not from the people.
Ms. Schroeder?
No, for the defense, thank you.
All right, Mr. Shakur, good luck to you, okay, sir?
Yeah, I think so. Yeah, you should be the one trying to do it.
That's okay.
I'm taking.
We had
And
an
we
old
call
one.
the new one, it's fine.
Oh, you can't touch it.
It'll be all special.
Yeah. as far as
Then I'm
I know,
gonna tear up the old one. 23-02832. It's people of the state of Michigan versus Marquise Demeyers. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Feigelson.
Yes, Your Honor, good afternoon, Assistant Public Defender Stephen Feigelson. On behalf of Marcus Demeyers, who's present and standing to my right.
And sir, you are Marcus Demeyers, is that correct?
Marcus Demeyers, yes.
Thank you. This is the time set for preliminary examination. From my notes and indication, we took an adjournment during the preliminary examination so that we could brief and if I remember correctly, we could brief the confrontation issue as it applies to preliminary examination. Okay.
Correct, yes.
Council was not going forward on the statute. They were going forward on something other than the statute.
On a hearsay exception,
Right.
that is correct.
Right.
And APA Smith is here and did write the brief, and she is prepared.
She wrote the
to make
brief
argument.
and answered all my questions, okay? Answered all my questions. Mr. Feigelson, do you have any response to Ms. Smith's brief? I think she dated it as of April 3rd, 2024.
Judge, I'll be brief in this. Part of the reason why I didn't file a response. I do believe she's correct with regards to confrontation, regards to the confrontation clause. What I guess I'm wondering is what portion of the hearsay rule is more appropriate, because she's arguing excited utterance. But I think to make it an excited utterance, there has to be some independent proof of the action. But if she argues number 4, then I'll leave it to the court. But I still think it's under the hearsay rules, we have a hard time proving that there's an independent act.
All right.
Evidence, I mean.
Yeah, I understand the argument. I'll leave I am thoroughly convinced that at a preliminary examination stage, that hearsay for our purposes pierces confrontation at the prelim. The normal trial court rules don't apply, which would make sense. There is some case law. Ohio versus Roberts is one of them that has to do somewhat of the preliminary examination, and an 804 federal rule out there that they wanted to use at trial, but that's like a 2003 or 4 case, and that is the case that Crawford changed. So in 2005, Crawford changed all those rules, so the actual trial judge was using the right rule, and they got overturned with whatever decision came out of Crawford. Now we pretty much set the stage. So, but as a confrontation, but this is a preliminary examination setting. So all these trial rights are different at a preliminary examination setting. So that understanding, the request was that whether you can use the hearsay rules, 803 rules to get past on a bind over. The answer is yes, but you still have to lay foundation for the 803 rules, whichever one you choose. Okay. With that understanding, had we gotten to a witness yet, or did it just?
Yes, Your Honor.
Was that Hutchins?
Yes, Your Honor, and Officer Hutchins is here to continue her testimony today.
All right.
Just to address one thing that Mr. Feigelson said, which the people would disagree with, there does not have to be a separate independent basis to lay the foundation for a hearsay exception. I believe Officer Hutchins had already begun laying that foundation, but I anticipate that APA Wilson will ask some questions to refresh all of our collective memories as to that. We also have another issue to address, and I don't mind doing that now or after, however the court wants to handle it.
You can do it now.
Okay, thank you so much, Your Honor. As the court is aware, the first date and time of this preliminary examination, the child victim was subpoenaed, as was the child's mother, again, because she's a minor child. Neither of those parties appeared on that date and time. I had a detective pay special attention to this case to have subpoenas issued for today's date and time. I'd like to make a record of those efforts, which will be necessary for the request that I'm making to this court. Detective Molly Brooks, MOLLIEBROOKS, emailed myself and APA Wilson on April 3rd, the day that our brief was submitted, and said, "Good morning." I attempted on Monday, which would have been April 1st, 2024, to make service. A male answered the door at 4245 West Jolly, lot 108, which we believe to be the party's address. He acknowledged that, I apologize if I say these names wrong, Sharisa and Malia live at the residence, but stated she wasn't home despite her vehicle being in the driveway. I heard a female voice inside the house, but didn't visualize anyone. The male then stated that Sharicia wasn't interested and refused to take any subpoenas and shut the door. I attempted to call her several times and no answer. She then, meaning Officer Brooks, emailed us again on Friday, April 5th, and said, "Good morning all, attempted the house again yesterday," which would have been April 4th, and continued to get zero cooperation from the male that answered the door. Sharicia's vehicle was in the driveway yesterday. I went to Holt High School this morning. Malia is no longer enrolled at traditional school. I confirmed with the virtual school that she is enrolled in virtual learning and there's no requirement for them to be in person at any time. I went again to the house this morning, which would be April 5th, and received no answer and left the subpoena in the door with my business card. Officer Brooks emailed shortly thereafter and said, of course, as soon as I sent that email, Sharicia called me back. The plan right now is that I will meet her on Monday morning at Diamonddale Elementary's parking lot where her son goes to school to serve the subpoena. She expressed a desire to talk to your office about further participation in court processes. I have attempted to call her several times and have not had any answer. The last email comes from Detective Brooks on Monday, May 8th. And she states, Sharicia was a no-show at Diamonddale Elementary this morning throughout school drop-off. I was there for 1 hour. Her phone sent me to voicemail twice with no answer, and I have attempted 3 separate times at the house last week. Based on all of these efforts, Your Honor, I am going to be asking that this court assert its authority in the issuance of a writ of capias. Your Honor, Sharicia is a necessary witness in this matter. She was on the phone with her daughter while the assault was taking place. So she is a fact witness. She has a duty and responsibility as the minor child's parent to comply with court orders. If her child is subpoenaed for court, she is required to either bring her child or arrange for her child's appearance here. At this point, she is evading all attempts to participate in this process. A court subpoena is not an invitation. It is an order. She is usurping the court's authority to have her and her daughter appear here. It's not my ordinary course of practice to ask for this type of measure, but I do believe in this instance it is required for the best interest of the minor child and her continued protection to ensure that accountability is held against her abuser and that the parent that she is in the custody of is doing everything in her ability to protect her child. So I am asking that this court issue a writ of habeas and will, based on the court's decision on that, likely ask for one further continuance based on her appearance once she is arrested.
All right, and so it's a writ of capias for the mother.
For the mother, correct, Your Honor.
What's the name?
I am looking at the spelling right now, but of course the internet likes to go in and out in this room. I believe the correct spelling is Shereasa, last name Miller, Miller.
Mr. Feigelson responds.
Judge, a couple of things. I mean, certainly, I don't represent Miss Miller, so I really can't advocate for anything in regards to her, but I want to talk about with regards to Mr. Myers. What I don't know is, has she been served with the subpoena? Because it's not a good thing to duck, but I don't think she's under any order yet to be here. My other concern is we presented this once to get everybody here to argue about these hearsay statements, and I'll address that issue in a second. But I would ask if they're not here, instead of adjourning it, they can always choose to refile this. But if they don't want to participate, maybe what they're alleging didn't exactly happen the way they alleged that night. And I think that also needs to be factored into this, Your Honor. So I'd ask for dismissal instead of the bench warrant. If they want to refile, they can refile, Your Honor.
Thank you. She is the mother of the 2 minor offenders. two minor victims, is that correct?
Only one of her
Only one
children
victim?
is a victim, Your Honor,
That's
and that would
Malia-
be
is that
Malia.
Malia?
Correct. Her minor child son was not involved in this, thankfully. But yes, she is the mother of Malia, who I believe is 15 years old. I'm just fact checking that based on her birthday.
All right, so let's
No,
let's do this.
15.
So, and she has been subpoenaed, and you can't serve the subpoena. That's the reality of it.
Correct. And pursuant to MCL 767.34, it's not actually required that a witness be subpoenaed in order to have a writ done. Oftentimes, these procedures are done in cases where we know ahead of time a witness is not going to cooperate for whatever reason. Perhaps they have their own legal issues to deal with. And preemptively, we do this before subpoenas have even been cut and run. So I do understand Mr. Feigelson's point that they haven't been served, but from my position, that's not a requirement.
So
for
let's do this. What we'll do is we'll set it for the CAFIAS hearing in the next, and what I'll do is wait for the paper. Because your office, because I've signed them before.
Yes,
And so I know your office can do them.
yes,
And you'll submit an order to me to sign for what you want done with the witness.
okay,
Whether you want to remand it, or whether you want some type of some type of assurance that she will get to court. This is a little different than some of the CAFIAS we've signed, because those are signed when the witness was obviously evading service. And so we remanded that witness for the testimony. As a matter of fact, I think we got we went out of state and got them to pick up the person and brought them here. I don't know if that would be in line with, but because this is a much more sensitive issue.
Mhm.
But I think that setting it for notice, bringing everybody here for a look at, and that also give Mr. Feigelson any time for any writ in response to share the order with him.
yes,
And then what you're asking for the sign, I'll take verbal arguments. It doesn't have to be in writing. But I'll tell you the truth right now. Unless there's an argument against it, I think this is the proceeding for the writ. Okay, this is the way I would writ it, because you can't serve the witness, and of course you can't serve the children, because that becomes a problem. And so we run into this. This isn't the first time that this has been an issue.
understood, Your Honor.
So what we'll do is we'll take the testimony that we can today. We'll adjourn for the writ to be signed, and I think we should have a hearing on that. An actual hearing, and then we'll reschedule the prelim elsewhere, the second phase. So let's go ahead and start the prelim with Officer Hutchins in regards to that testimony, and then we'll set it for the motion and for the adjournment of the preliminary examination. Mr.
Very
Feigelson.
well, Your Honor. With regards to the writ, I mean, I think I get the court's point, so I guess I don't think there's an issue to contest that when they can pick her up.
All right.
But the issue I want to bring up is with regards to the hearsay. Ms. Smith said there isn't a hearsay exception that requires independent proof. If she's arguing under the excited utterance exception, there is a case on point, People versus Burton, that says there has to be some independent event that would give her circumstance.
Freezing of the mind, so to speak.
Yeah, that to show that the mind was, that she was startling offense. I don't know if there's been testimony listed
Your
yet to
Honor, I do
argue
have a
that.
response to that.
All right.
Quickly. Under People v. Barrett, which is a 2008 case, the excited utterance may be considered by the court in determining that the startling event occurred. People versus Burton is overruled. So that argument holds no water.
All right, and the freezing of the mind was always one way to make it the excited utterance. There were many other ways, including a freezing of the mind years before, when you actually blurt out something in response to something that happened. So that trigger response may not be to the actual excited event. It may be somewhat after. I'll leave counsel to make those arguments, but I'm sure that counsel will object if the hearsay seeking hearsay to pierce confrontation becomes an issue, and then counsel can lay adequate foundation. If that's the case, then it would probably be more efficient to complete the order, share it with Mr. Feigelson, so he knows if he requests, he can have a hearing to fight it. If he believes that writ of capias is proper, you can submit it to the court and we don't have to have the actual hearing on the writ.
Okay.
Because we have an attorney in regards to the defendant. So share it with Mr. Feigelson. If Mr. Feigelson says we should have a hearing on it, let's have a hearing on it. If not, we'll just set this for an additional preliminary examination.
Understood, Your
I don't
Honor.
have an issue. The only concern is that if she's giving me a writ based on somebody I don't represent, I don't think we have an interest.
Yeah, I don't know. The only
Argue against that. Right?
the only indication would be whether you're right, because but the writ is for a witness, and I'd like you to take a look at it to see if format wise it's correct.
I'm okay with that, Judge. I just don't think I'm standing to.
I don't think you do either. I think that's fair. I think that's a fair statement.
I think it's a best practice, though.
Yeah.
We'll make sure that Mr. Feigelson has a peek at it, and we'll get that to the court before this weekend.
All right, and then with that being said, we are going to adjourn the prelim, but we're going to get the testimony in that we have, and then we'll adjourn the prelim to see if the writ has any ramifications. Okay.
Understood, Your Honor.
All right. So Ms. Wilson, you can call or recall to the stand Officer Hutchings, and then we'll start from there.
Thank you, Your Honor. Yes, the people will recall Officer Hutchings.
Okay. And then bring it to the court's attention if there's anybody in I see security's in the courtroom right now, but if there's anybody comes in that we need to sequester. All right, Officer Hutchings, you can come up here. I'm going to swear you in again because we already have done it. Please state your first name and last name and spell them both for the record.
Melinda Hutchings, MELINDA HUTCHINGS.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Okay, have a seat. The microphone is for recording. Please project to the back. And Ms. Wilson, when you're ready.
Thank you, Your Honor. So Officer Hutchings, just to kind of refresh everybody's recollection, I believe you previously testified that you were working as a police officer on August 8th of 2023.
Yes.
Okay, and you also previously testified that on that date you were dispatched to 1300 Georgetown.
Yes.
Okay, and you said that you made contact with somebody at that address, is that correct?
Yes.
Who was that?
Malia DeMyers.
Okay, and what were you dispatched for?
It was initially an unknown trouble.
Okay, and when you got there, you made contact with Mr. Myers, is that correct?
Yes.
Okay, did she say, what was her demeanor?
She was very emotional.
Okay, and can you describe a little bit what that looked like?
She was crying and kind of out of sorts in that manner.
Okay, and did she say any statement as to why she was upset?
Yes.
And what was that?
She told me that she was assaulted by her father.
Okay, and did she say anything further about how she was assaulted?
Yes.
What was that?
She said it started when she was picked up by her father and brought to her grandfather's house, which was the Georgetown address. She said that her father was upset with her because he believed she got an attitude with him. And when they got back to the Georgetown address, she told me that he took his belt off and began hitting her in the legs with the belt.
Okay, and did she say anything else?
Yes, she said she grabbed the belt to stop him from hitting her, and then he struck her in the leg several times. After that, she said she fell to the ground and dropped her phone. She said that her father picked her phone up. And when she got up, she said that her father then grabbed her by the throat with both hands and began choking her.
Okay, and when you say choking, did you describe what that meant?
She said she had trouble breathing.
Okay, now, while she's telling you this, is she still upset?
I believe so.
Okay, did you have occasion on that date and time to observe any physical parts of Malia's body?
Yes.
And where did you see anything of note on there?
I saw red marks on one of her legs.
Okay, and did you take photos of those marks?
Yes.
Okay, for the record, I am showing the defense attorney, People's Proposed Exhibits 1 and 2.
Let the record reflect that defense is looking at People's Exhibits 1 and 2.
All right, may I approach, Your Honor?
You may.
Officer Hutchins, I'm handing you people's proposed exhibits 1 and 2. Do you mind taking a look at those real quick? Do you recognize those?
Yes, I do.
And what are they?
They are welts on, looks like the left leg.
Okay, and what is the actual thing that I handed you?
2 photos.
Okay, and how do you recognize those photos?
I do.
Okay, are they fair and accurate representation of what you saw that day?
Yes.
Okay, now you said that you saw some welts on her leg, is that correct?
Yes.
Is that in accordance with what she described had happened with the belt on her leg?
In my opinion, yes.
Okay, Your Honor, I would ask to admit people's exhibits 1 and 2.
Any objection to people's 1 and 2 for preliminary examination?
No, Your Honor.
Without objection, people's exhibits 1 and 2 are admitted in evidence.
And permission to publish, Your Honor?
You may. Thank you.
Nothing further for this, witness, Your Honor, thank you.
All right, cross-examination, Mr. Fikes.
Yes, Your Honor. Good morning, Your Honor. Or good afternoon, officer. So you got dispatched out to Georgetown, Lieutenant Georgetown, is that correct?
Yes.
And that was around 1 in the morning on August 3rd of last year? And you said you ran into Malia DeMyers, is that correct?
Yes.
And that's the first time you've ever met her, is that correct?
To my knowledge, I believe so.
And she told you that she said that she was giving her dad an attitude, is that correct? Did you ask her what she meant by that, or what went on?
I don't recall.
Now, did she say he picked her up from her cousin's house at the request of her mom, is that correct?
Yes.
And you said you looked at her and were able to see bruising on the left leg, is that correct? Red marks, is that correct?
Red marks, yes.
Do you see any bruising or abrasions on her chest, or the chest, but neck, excuse me?
I don't recall.
And you made an accurate police report, is that correct?
Yes.
The police report doesn't say anything about witnessing marks on the neck, is that correct?
Yes.
And you said you took 2 photos, is that correct?
Yes.
And you said she got hit with her belt, is that correct?
Yes.
Do they look like they were from the belts or scratches or bruising?
In my opinion, it appeared to be more in line with the belt mark.
Did you do anything else that night besides speak with Mr. Meyer?
No, I don't believe so.
Were there anybody else present in the home?
Her grandfather was. I didn't talk to him.
And just the 2 of them only went there, is that correct?
Yes.
Were you by yourself or were you in a boss unit that night?
I wasn't with the Boston unit, but I had an additional officer respond with me.
And that officer interviewed the other person, is that correct?
Yes.
And since this date and time, besides coming to court here a few weeks ago, you've done nothing else on this case, is that correct?
Correct.
I have no further questions of this one.
I'll redirect Ms. Wilson.
Just one question. You said that the grandfather was in the home, is that correct?
Yes.
So at that time, Mr. DeMyers was not present?
No.
Okay, nothing further, Your Honor.
Just in clarification for me, and then I'll give counsel a chance for cross-examination purposes. When you, and I could have missed this, did the person who you talked to give you, did you get an age from them?
I don't recall.
So the person who's in these pictures, you don't recall what their age is?
Not off the top of my head.
Right, any follow-up questions, Ms. Wilson?
Yes, Your Honor, briefly. Officer Hutchings, would reviewing your report refresh your recollection as to the age of the individual you spoke with?
Yes.
Your Honor, may I approach?
You may.
And I can't remember the number of the report that I just handed, but I believe it's 2 something.
I don't think it's not an admission.
Yeah, right. Officer Hutchings, did you have an opportunity to review the report?
Yes.
And is your memory refreshed as to the age of the individual that you spoke with?
Yes.
And what was the age? All right, nothing further, Your Honor.
All right, Mr. Feigelson, any questions?
Just 1 or 2 off of that. So you said she was 14, is that correct?
Yes.
And she was a minor, is that correct?
Yes.
And did you get permission from one of her parental units to speak with her about that event?
Objection, Your Honor, relevance.
Response?
I think it is relevant to see if she had gotten permission, because she can't talk to a minor without consent of the parents.
What's the law on that? Where does it state that you can't talk to a child without a parent's consent? She was not being questioned as a suspect.
Right, so it would trigger Miranda or something along those lines. So, Mr. Feigelson, are you just asking if she had anybody else question just to see of the procedure? Or are you saying that that statement is somehow constitutionally excluded from
No.
use?
No, I'm not arguing this guy.
All right. All right, so you can, so I'm gonna overrule the objection as relevance. You can indicate if you had anybody with you when you interviewed the 14-year-old.
Initially, it was just the 14-year-old. The grandfather was in the apartment where he closed the door, and then mom showed up on scene.
Okay. And do you know if mom called the report in, or was it the child, if you know?
I don't recall.
Did you speak to mom?
No.
Okay. I have no further questions, ma'am.
Thank you. May this witness be excused, or do you have any other follow-up questions, Ms. Wilson?
No, Your Honor, she may be excused.
All right, thank you for your appearance. You're all set.
Thank you.
Are there any further proofs today from the people, Ms. Wilson?
Not today, Your Honor. We just request that adjournment that we spoke about preliminary matters.
So we talked about this in the preliminary matters as to the writ being supplied for additional witnesses who have been attempted to be served and unable to be served. And out of courtesy, they would give it to Mr. Feigelson in order to review the documentation. Because as Mr. Feigelson indicated, he's not representing the person the writ is, but he'd still like the idea to see it in order to take advantage or in order to review any capias written on this case. We'll reset the prelim for additional testimony. And so the question is, how fast do you expect the writ to be done? And then when should we, what's our time frame are we looking at?
Your Honor, I anticipate being able to complete the paperwork that needs to be given to you prior to the end of day tomorrow. So if
Okay.
I could have it signed by Monday, I don't believe that this witness is going to be hard to locate, and it's not my intention to keep her for a long duration of time in custody. So if honestly, if Your Honor had time to do this perhaps on the 25th in the afternoon, I think that we could make that work.
We can do, now I'm gonna talk to the person who does the scheduling. And so,
That does work for me. You're talking the 25th.
so
25th can work for me.
25th in the afternoon, or it would be the following second or third.
The 25th in the afternoon, we have one. We have approximately 6 several motions scheduled. And that's it. They look like they could be lengthy.
How about the 26th? But nobody wants to do on a Friday afternoon.
Your Honor, I'm
I'm
just letting you
open.
know, for the record, that I'm gonna be out on the 26th. My husband's graduating from college that day. And I'm out the following week for a training. Having said that, I think that Ms. Wilson is perfectly capable of picking up where I've left off on the
Alright.
procedural aspect. And once the witness is available, she'll have no problem handling that on her own.
So
We do the 25th in the morning.
can you do the 25th in the morning?
I can, Your Honor. I'm here in the morning.
I can.
All right, we'll do the 25th, April 25th. This is probably the safest because once we
9
get
a.m.
into May has a holiday, it's got a couple weeks already off, so this is probably safest, April 25th.
Let's just do 10:30. That should get everything cleared out.
All right, we'll do April 25th at 10:30 for the adjournment on the prelim. Mr. Feigelson, did you have anything to add?
So two things I'll add, one in regards to this. How are we gonna treat next week in the event that they haven't been able to pick up the mother in that time?
That does not come under capias?
Yeah,
Yeah. It's a valid question. I don't know if we'll know that,
right.
but
Your Honor, I'm happy to provide an update to the court and Mr. Feigelson by close of business on Wednesday, the 24th,
okay,
as to whether or not we have her in custody.
right.
And if we don't, if we can just administratively push it out another week or what have you, I'll defer to the court, but I will note that as soon as she's picked up to let the court know, and if I don't know by Wednesday at around, let's say 4 o'clock, I would let everybody know.
All right, so we'll know by Wednesday if.
I
court
I
ever needed
don't have a
it.
problem leaving it down, but I think if we can't get her in a week, I'd be willing to move the argument and move this case along.
Right, I'll entertain, I definitely will entertain an argument on that, on the 25th, if we're unable to proceed on that time.
May I address bond as well?
You may.
Mr. Myers? I know that at one point he had a personal recognizance bond. I believe we changed that because he was sitting in jail on a sentence. And I believe that sentence ends it ends on the 24th, Your Honor, so I'd ask for that original PR bond to get reinstated on the 25th.
All right, so the question, response, any response to the reduction of bond? We have a date set for the 25th at this time. So from the people.
I have his out date as May 10th,
So you have his out date as May 10th.
although it says eligible sheriff till they're 4/24. So that's when he could
Right.
potentially get out, yeah.
All right, so
So I would request some kind of cash surety if it's another week.
but let's revisit this on the 25th.
Okay.
On the 25th, we'll revisit this. It doesn't appear that Mr. Demeyers isn't going anywhere. And if Mr. Myers is out in the next week, it certainly doesn't make me feel comfortable with the children involved in the case. So we will revisit this on the same date on April 25th at 10:30, once we understand the nature where this case is
So
going.
that we can address on 25th, but I do want to make an offer of proof to the court. I do believe, and no testimony has been brought out yet on this, that child and defendant do not live together, and I don't think they've ever lived together, so I don't know if would be a concern of safety for the child.
Only with the continuing problem with getting the child and the parent. And now we have exhibits 1 and 2 admitted in regards to both of the proofs of count 1 and count 2 in this case. So we will revisit on April 25th at 10:30.
Thank you.
Anything else for the record? 2302-832, Ms. Smith.
No, Your Honor, thank you.
All right, Mr. Feigelson, anything else?
No, Your Honor.
You're all set. Thank you for your appearance today. And then I'll give you back the exhibit.
Oh, thank you, Your Honor.
Get out.
Both finals.
When I get back to the office, I will,
Okay, yeah,
and I'll send it to you just so you know what they look like if you need them in the future.
No, you can send it to me today. I'll have a chance to look at it.
Okay, I'm gonna try and do it today is what
Yeah.
I'm saying, but it might end up being tomorrow.
Yeah, that's
But it
fine.
will
too.
definitely be to you ASAP.
I'm sure I'll look at it tomorrow. for sure.
Okay. I just have to